Hey guys, welcome to Module 3 short lecture. And in this first short lecture, I just want to talk about the importance of the courts. And then I'm going to end up just talking a little bit about punishment because it'll tie into your journal assignment for this week. So let me move into the short module lecture here. You're going to get, at the beginning of the chapter, you're going to get an overview of our courts in terms of an historical perspective. And so just remember that much of the law that we have in this country originally came from England. So we mirrored some of those concepts, which really wasn't out of the ordinary considering that our founding fathers were primarily English. So we did get a lot of the ideas and concepts associated with the court from England. Now, one of the things we did develop here as our founding fathers developed the federal government and then state governments is we developed a dual court system. And so basically that means there are two types of courts in the United States, state courts and federal courts. Odds are you and I will have more contact with state courts than we ever will with federal courts. And oftentimes it's because the type of cases that each of those types of courts will hear. And we'll talk about that here in just a little bit. But just remember, we have a dual court system, state courts and federal courts. Our system is an adversarial one. It's a legal system where there's a contest between two opposing sides, typically a prosecutor and a defense attorney, with a judge and possibly a jury, depending on the type of trial, sitting as an impartial arbiter seeking the truth. Our system relies on the adversarial system, which uses several means to get at the truth. And so, for example, cross-examination, a prosecutor may call a witness, and then the defense has an opportunity to cross-examine that witness. So a lot of it is adversarial as we try to get to the truth. And you've seen plenty of shows on TVs where the prosecutor brings on a witness and the defense sort of tears the witness apart. And so you begin to see how adversarial our system of courts can be. Now, there's a couple of interesting couple of interesting concepts that you need to understand when you talk about the courts, and that is jurisdiction and venue. So jurisdiction is the authority of a court to hear and decide legal disputes and to enforce its rulings. Venue is the geographical location to which a case is tried. So, for example, federal courts will only have jurisdiction over matters of federal law and the U.S. Constitution, which is mainly why most of us will never, ever be in federal court. So if a police officer, for example, falsely arrests someone, that's a violation of the Fourth Amendment. That's that's an unlawful seizure. So the person who was subject to the false arrest can sue the police officer, the local government in federal court for violating his or her Fourth Amendment rights. Okay, that's jurisdiction. So federal courts can only hear cases involving violation of federal law or violations of the U.S. Constitution, where state courts can hear cases involving violation of state law and state constitutions. So if I burglarize a house in Los Angeles, and I get arrested and charged, I will be tried by the state of California. All right, I will not be charged or prosecuted by the federal government because burglarizing somebody's house is not a federal crime. It is a local crime. So that's the key thing with jurisdiction. Now, venue is going to be the location where a case is tried. So typically, the court that has venue to hear a case is going to be one in which the crime occurred, a geographical location. And I'll show you an example here using the federal court system. All right. So in the United States, there is at least one district court for each state. And I offer you a short video that I hope you'll have time to watch to explain this. Some states, because of their size, have more than one district. So what I'm showing you here is the United States District Court for the Central District of California. Now this Central District of California is the federal court district when I was working in law enforcement that had jurisdiction. So the city I work for sits right in here. It's in San Bernardino County, but it brushes up against LA County, Orange County, and Riverside County. So this little area in here. So if a federal crime were to occur in San Bernardino County, it would be part of the Central District of California. That's what have jurisdiction. But more specifically, based on how the courts in the Central District have divided venue, is the proper venue for a federal crime occurring in San Bernardino County would be in the Eastern Division, San Bernardino County, Riverside County. And that federal courthouse is located right about here in Riverside, California. So that would be the proper venue. So if I committed a federal crime in San Bernardino County, I would go to the Riverside. There's a federal court in Riverside County. That's part of the Eastern Division. So it's the Central District of California, Eastern Division is where the venue would be, okay? It would not be up here in Santa Barbara County or San Luis Obispo County. It would be here because these counties are part of the Western Division, and then we have a little bit here in Orange County that's part of the Southern Division. Okay, so that's about venue. So once you establish jurisdiction, you then have to determine venue. Where most cases begin in state courts, I just want to talk about how state courts are structured real quick. State courts typically have anywhere from 3 tiers to more than 3 tiers. New York State is very complicated in terms of its court structure, and there's other classes where we talk about that. But right now I just want to focus on the different structures within state courts. So at the bottom rung are courts of limited jurisdiction. These are your lower courts. These are often called justice of the peace type courts. They often will handle infractions, tickets, misdemeanors, some civil cases under a certain amount. And in some states, they may hear preliminary hearings on felony cases. But these are courts of lower jurisdiction, all right? So most of us probably have some experience with courts of lower jurisdiction. So if you ever got a parking ticket, or if you ever got a speeding ticket, or something along those lines, you probably dealt with these courts of limited jurisdiction. Then in state courts, we have trial courts of general jurisdiction. So these are your major trial courts. So they will hear, typically will hear felony cases. So homicides, things like that are tried in these type of courts. These courts will also hear the more serious civil cases, generally suits over $5,000, for example. A lot of times, these trial courts of general jurisdiction also deal with family law matters, juvenile matters, things like that, right? These courts often have both time and resources to devote to these more serious offenses because, let's be honest, most criminal offenses are crimes that occur are misdemeanors, right? So a lot of misdemeanors out there, not so many felony cases, all right? Same way with civil cases. A lot of civil cases under 5,000, not so much over, okay? Those are going to be more serious cases, and those don't, they occupy the court's time, but not to the extent that we see in small claims courts, things like that. So these are trial courts of general jurisdiction. And then if you want to appeal anything from the trial courts of general jurisdiction, most states have an appeals court, right? Now these courts stand between the trial courts and the courts of last resort, which are often state supreme courts, and they typically have appellate jurisdiction only. That is, they only hear appeals. They don't hear any witness testimony or anything like that. Oftentimes, attorneys will file their legal paperwork, their briefs with the courts, and then the courts may allow them to respond and then answer questions that the courts might have. But again, the appeals court's job is primarily to ensure that the lower courts have applied the law correctly, right? And they provide some guidance as well to the lower courts. So again, their role is error correction and guidance to the lower courts in applying and interpreting the law. That's the primary reason we have appellate courts. But again, usually you're going to appeal matters in which you think that the law was misapplied in some fashion or another. And then we have state courts of last resort, which I mentioned down here, and these are state Supreme Courts. And these are the final arbiters of the law within the state. All right, so if the state Supreme Courts hear a case and make a ruling, then it's going to be applied throughout that particular state. The decisions on appeals courts, depending on your state, but most states, the appeals court's rulings are binding on the whole state unless the state Supreme Court elects to hear that particular case. Now, the federal court system is pretty straightforward. It's a three-tiered system. So we have the Supreme Court, the United States Supreme Court, circuit courts of appeal, and the district courts. The federal trial courts or the U.S. district courts are the workhorses of the federal judiciary because nearly all civil or criminal cases heard in federal courts are initiated at the district court level. The appeals courts then are the United States Courts of Appeals, the circuit courts. And again, their primary role is error correction. They aid the lower courts in interpreting the law. And this is an incomplete thought here, but as you saw in the map, and I'll show it to you here, the circuit courts, U.S. circuit courts, are divided into districts, okay? And so here they are. There is a 12th district, but we're not going to mention that right here. It's the federal district right here. So you can see how the federal courts, the courts of appeals, are structured. So, for example, if I lived in Denver, Colorado, I would be in the 10th Circuit. Now, the unique thing about the Court of Appeals is this, that if the 10th Circuit Court of Appeals renders a decision, let's say police, a case involves a search of something, and they make a ruling, that ruling applies to all people within this circuit. It will not apply to people in the 9th Circuit or the 8th Circuit, only to the 10th Circuit. So if they make a legal ruling on a search and seizure issue, it only is going to apply within this circuit, all right? And that's one of the unique things about the federal court structure is that rulings within a specific circuit are only applied to those courts within that circuit, not the whole United States, all right? Same way with the 9th Circuit. The 9th Circuit makes a decision on a case in Washington involving search and seizure issues, then that ruling applies to all states that comprise the 9th Circuit, and that's quite a few, as you can see. Okay, so that's the interesting fact about the circuit courts within the federal system. But again, they have a job, and that is role in error correction and making sure that lower courts apply the law correctly. Okay. And finally, we have the United States Supreme Court, the highest court in the nation, the court of last resort in the United States. The United States Supreme Court hears only a handful of cases, a small percentage of cases, and usually those are cases involving or raise a serious constitutional issue, such as same-sex marriage, or those that raise an issue or conflict within federal law. In other words, the circuit courts are in disagreement as to how to interpret a particular law, and so the Supreme Court will often hear those type of cases. The thing is that when the Supreme Court speaks, it speaks for the nation, so that if the Supreme Court makes a legal decision on search and seizure issues, which it has, because you've read several of them, then that law is binding on the whole country. I'm not going to get too much into the pretrial process, the pretrial processes that takes place. You can take a look at that. I'll also provide this in a written form so you can have it as part of your research material here for this particular segment. So you could take a look at that. I do want to spend just a minute talking about the purposes of punishment. There are 4 goals of punishment: retribution, deterrence, incapacitation, and rehabilitation. Retribution is an idea of revenge, an eye for an eye. Deterrence, prevent future crime. So in other words, punishment should act as a deterrent to the general population, okay? We also have general specific deterrence. Specific deterrence is laws designed to prevent an individual from committing future crimes, and so those would be like your habitual offender laws, things like that. Incapacitation, you lock somebody up, you're moving from society, prevents victimization. And then rehabilitation is the ability to reform an offender through programming. This week you need to tie this into the death penalty. All right, so take a look at that carefully. I will have this available to you